Hi, my name is Mark O'Keefe. I'm executive editor for Herald-Standard.com, and I want to welcome you to this Herald-Standard.com editorial board meeting with the candidates for Fayette County District Attorney in the November 8th general election. I want to thank the candidates for agreeing to meet with the Herald-Standard.com editorial board. And the candidates are Republican John S. Cupp Jr. and Democrat Jack R. Hennicks Jr., who was appointed district attorney in 2010 when former DA Nancy Vernon resigned after being elected Fayette County judge. So the candidates will get 3 minutes to make an opening statement, 3 minutes to make a closing statement, and you'll have 2 minutes to answer questions from the members of the editorial board. So we'll go by the alphabet, so we'll start with Mr. Cupp.
It's a curse of having a last name that begins with the beginning of the alphabet. I want to thank you for inviting me here today. I was born in Connellsville and graduated from Connellsville Area High School in 1968, living my whole life in Fayette County, even though I worked away for several different periods of time. I am licensed as an attorney and a certified public accountant. I'm a member of the Pennsylvania and West Virginia bars. I have practiced law since 1982. I believe the district attorney's office needs change to make it more organized. I cite the case of Siripco, which is the Dear DNA case, as an example of the disorganization in the district attorney's office. And we have copies of the opinion. The judge reviewing the case described the record in a memorandum opinion of July 27, 2011 as follows. We would be remiss if we failed to comment on the deplorable manner in which the Commonwealth filed the answer to this petition. The court received an unbound packet containing well in excess of 1,000 pages, arranged in some indeterminable random order, and was required a great deal of considerable time attempting to segregate the documents required to address the petition from the vast volume of superfluous materials submitted. The district attorney is put on notice that in the future we will refuse to accept the challenge of performing his work and attempting to put the documents in some usable order, avoid losing any pages, and expending considerable valuable time attempting to do so. I believe the district attorney's office needs reorganized, if not organized, and I will do so, and I thank you.
Okay, thank you very much. Okay, Mr. Hennicks.
Thank you, Mr. O'Keefe. I'd like to thank the Herald-Standard, members of the editorial board, and distinguished citizens on this committee for allowing us to participate in this event. As indicated by Mr. O'Keefe in the opening, I have been the district attorney for the last 2 years, taking over for Nancy Vernon when she became judge in January of 2010. Prior to that, I was the child abuse prosecutor, became the first assistant under Nancy Vernon, and as a result of that position, when she was elevated to the bench, became the district attorney. I'm proud of my record in the district attorney's office for the last 15 years. I prosecuted probably hundreds of cases during that period of time, obtaining a verdict of guilty in most of my cases that I prosecuted. I'm proud of my record for trying to root out child abuse in Fayette County, both physical and sexual abuse. It's something that has gratified me over the years that I've been able to do my part to be able to bring justice to the victims of child abuse in Fayette County. I have followed through with that in my 2 years as district attorney. Our conviction rate is over 70%. We have tried about 198 cases over that period of time. If you look at other counties throughout the state, our record in trying cases and obtaining convictions is among the best in Pennsylvania. In some ways, only Philadelphia and Allegheny County in the years past have tried more cases than Fayette County. And of course, their populations are much larger. I give credit to our assistant district attorneys who do a yeoman work on a day in and day out basis in bringing those cases to trial. In addition to that, we're at the preliminary hearings. We attend all the omnibus pretrial hearings, and I'm proud of my record. In addition to that, I'm also proud of the fact that I'm the head of the Fayette County Drug Task Force, and in that capacity, we have obtained several large busts taking heroin and cocaine and pills, which are becoming, in fact, more prevalent each and every day, off the streets of Fayette County, prosecuting and convicting those criminals, and in fact obtaining some of their properties that were used in the crime, their cars, their cash, and their houses. I'm proud of those efforts, and I will pledge that if elected in November, that I will continue to make Fayette County District Attorney's Office the best District Attorney's Office in Fayette County, and I pledge to do that.
Okay, thank you very much. Okay, I'll take the first question. There have been a number of recent child abuse charges filed recently in Fayette County, and one case involving a homicide. Do you think these are isolated cases or part of a growing problem in Fayette County? And what can the District Attorney's Office do to help deal with the problem? We'll start with Mr. Hanks.
Unfortunately, we've had a number of not only child deaths, but serious aggravated assaults involving children, particularly in the last several months. All of those kind of crimes are something to regret. As far as whether they represent a trend or not, I'm not sure. We certainly prosecuted our share of sexual abuse and physical abuse over the last 15 years. I did myself prosecute several homicides. A 2-year-old child was killed, and I prosecuted the Franklin Weimer case that he's currently now serving a long sentence. And I might add that that was another case that the federal district court has just recently upheld the conviction, as in the Siripko case. Mr. Cupp fails to mention that the federal district judge upheld the conviction of Mr. Siripko and Mr. Weimer, and they are not going to be out on the street under my watch. So I believe that in regard to the child abuse cases, that I stand in the unique position to be able to understand those cases. I prosecuted those cases. I've done a number of shaken baby cases, and unfortunately were either homicides or very seriously maiming those children. And so I believe that with my work with Children and Youth Services, with the state police, with the local police, with the Crime Victim Center, that I'm able to bring the multifaceted look at that, multidisciplinary look at that, that I've been able to do and did during the 14 years before I became district attorney. And I'm proud of what Linda Cordero, who has taken over some of my duties in prosecuting those cases, and just recently obtained convictions in some very serious child abuse crimes. So what I am going to do and what we're doing, I just met with Reuben Memorial Hospital doctors in regard to one of those child's deaths. We've sat down with the doctors, looking at those cases, getting ready to prosecute those cases, and I think I can bring my unique talents and perspective and experience to bear in basically combating child abuse in Fayette County.
Okay, thank you very much. Okay, Mr. Cupp.
Well, it's interesting that we talk about Mr. Weimer. Mr. Weimer filed a petition for release in federal court which was just decided on September 29th, 2011. Judge Conte, the federal judge assigned to that case, had much to say about that case in the record in that case as well. I've given you a packet to see what Judge Conte said. You have to get the yellow highlighted area on page 2. The state record, quoting Judge Conte, the state court records reproduced by respondents are so poorly organized as to appear to be the result of the scanning of a pile of random documents related to petitioners' underlying criminal cases. Respondents attempted to group the record into 97 numbered exhibits. For reasons that are unclear, these exhibits were scanned onto the docket in 44 electronic documents and were arranged in a manner that does not correspond to the exhibit list that was provided. Adding insult to injury, respondents included the following message at the top of this filing. Note, exhibits were numbered and scanned prior to this list and are now out of order. Notations are made as to what exhibit they were scanned as. The notations provided by respondents were inconsistent and largely inadequate. In order to adjudicate this case properly, this court was forced to comb through roughly 3,600 pages of exhibits provided by respondents
30 seconds.
and create an index cataloging which exhibit on the docket contained which documents from the state court record. This undertaking was not a trivial matter, and it unnecessarily and unacceptably delayed the resolution of this case. See Dubler's Pennsylvania Hybrids versus Dubler, noting that judges are not like pigs hunting for truffles buried in the record. And I would be happy to say the federal courts uphold convictions despite what the district attorney does.
Okay, thank you very much. Okay, second question. You want to take it, Jerome?
Sure. Do you think stricter laws are needed to help prevent child abuse, or do you think there should be stricter enforcement of current child abuse laws?
Mr. Cupp.
I think that stricter laws probably are not necessary. The general need is to enforce the laws we have on the books. And we have some very good laws. We have laws that require people to register whenever they are discovered as a sex offender. We have laws that require people to go through a great deal of imprisonment when they're convicted of crimes, most notably those sexual offenses against children. And I think what we need is stricter enforcement.
Okay, Mr. Ennis.
In answer to your question is that I don't believe that the laws are necessarily the issue in these cases, although we've gone through just recently a loophole in the Megan's Law that I believe that the legislature unintentionally did that probably needs to be resolved so that out-of-state offenders who are subject to lifetime registration requirements are definitely subject to Pennsylvania registration rules. So I think that's one area that the legislature certainly can address. In regard to the matter of stricter enforcement, I think what my approach and what I indicated before is that we need to make it a multidisciplinary approach. We need to have that child that is either physically or sexually molested. We need to have that child examined. I know that a child's place in Mercy Hospital is currently on the verge of taping child interviews. We're hoping that that can result in better prosecution, fewer interviews, the ability to free up children and youth services to do some of the legwork that they need to do in those cases, and also to be able to go into families and to prevent further child abuse by interacting with the families to frankly give them guidance and support, and also be there if there's problems with that family. So those are the efforts that we need to keep doing, and as I've indicated, I certainly have seen from the start to the finish of those cases what needs to be done. As I've indicated, I've prosecuted probably
30 seconds.
100 child abuse cases. I don't think Mr. Cupp has prosecuted one. And I believe he's defended one case. In fact, it was a sexual assault case that I believe the last debate he said it resulted in a mistrial. His client ultimately pled guilty to a charge in that case. So I believe that's his. I believe he's tried a second case in the last 6 months in Fayette County Court. And as far as I know, that's the only cases that he's tried. So I think the determination that the electorate certainly has to make in this case is to choose someone who's tried 400, 500 cases, including hundreds of child abuse cases, or one who has tried 2.
Okay, thank you very much. Okay, we'll move on to the third question. Want to take that, Terry?
Fayette County currently has a treatment court which focuses on mental health issues and related drug and alcohol problems. There's also been talk about creating special drug or DUI courts, as has been done in other counties. Do you think these courts are a good idea, and what do you think about expanding them?
Start with Mr. Hennicks.
I think they're a great idea. I think that they come at the problem of the criminal justice from both sides of the political spectrum. From one side of the political spectrum, they provide the opportunity to get treatment for individuals so that they are in fact not coming back and doing those crimes. They provide a way in which we don't have to use our resources to send them to jail, to send them to a setting where they're not going to get treatment, where they're going to come out worse for wear after going through that. So from that standpoint, I think it's an excellent idea. We were just at a meeting today, in fact, of the Criminal Justice Advisory Board, where we're expanding it into veterans. And in fact, Todd Conner, who's the head of the veterans, was indicating, looking at other counties, how much farther ahead Fayette County is than a lot of other counties in that regard. And I'm proud of that because I was part of that process. From the other side of the coin, from the other political spectrum, it's going to save money. Certainly somebody on outpatient is going to cost far less than being in jail. Secondly, it's going to stop people from, or at least hopefully stop people from committing additional crimes. It's going to cut recidivism because it's going to be able to treat those individuals in mental health court. What we do is we have what's called reinforcement hearings, which means it's not just probation. You go in the probation office, you show up once a month. You have to go to a treatment team. You're monitored. If you start slacking off, that treatment team is there to monitor that progress or lack of progress, goes back to the court, reports on that, and then steps can be taken to make sure that that they don't get further in a situation where they're going to reoffend.
You have 30 seconds.
So I am in support of those kind of alternative treatments. I think that's the growing trend in criminal justice. I can't really see the downside in that because it gives the treatment for that individual, also protects the public, and frankly, as a district attorney, that's what I want to do most of all, is protect the public. And we're certainly not going to protect the public by sending a drug abuser to jail for a few years, comes out, and within the next month he comes out, reoffend again. I'm not going to say that I'm naive enough to say we're going to cure all the people of that, but at least we're going to attempt to try to do so.
Okay, thank you very much. Mr. Cupp?
I think that specialized courts are a very good idea. I think they address particular problems, and I think that that's an economical and responsible way for the court system to move. The district attorney should be someone who cooperates and joins in that system, and as district attorney, I would do that. In response to one of my opponent's comments, during the past, there has not been a bright line where the courtroom skills of the parties vying for the district attorney's office could be compared. There is no contest like a trial to show the contrast of skills. I believe there was only one jury trial where Mr. Hennicks and I locked horns and tried a case together as adversaries. I've given you the April 7 1999 Herald-Standard story which talks about the case, to which Mr. Hennick's alluded. The case resulted in a hung jury followed by the court declaring a mistrial. This could be interpreted in a number of different ways. The original offer was a plea to 5 to 10 years in one case and 3 to 6 running concurrently on the other case. After the case was tried and a mistrial was granted, Mr. Hennick, whose signature appears on the documents, agreed to a plea for 1 to 12 months of house arrest with credit for a week or so already served. The monumental reduction of the penalty is substantial.
You have 30 seconds.
Despite allegations by the incumbent DA that I don't handle cases or appear in court, so far this year alone, I have appeared in court 74 times, 20 of which were on criminal matters, and I have tried 2 jury trials this year.
Okay, thank you. Mr. Hanks? Oh, we already...
I was going to say, I think I was already asked that question, wasn't I? That's what I was wondering.
Sorry there. Okay, we'll move on to the next question. The legislature recently passed changes to the charge of drug delivery resulting in death, which will again allow police to file the charge against those who sell drugs to people who overdose and die. How difficult do you believe it will be to prosecute this charge, and do you believe this charge can help deter drug sales? Mr. Cupp.
I suppose the question as to whether or not a law will deter crime is a philosophical question which I don't know that I can answer. I think that conviction and imposition of penalties for individuals who commit crimes is an important factor in deterring crime. The addition of additional charges by virtue of someone dying as a result of a drug overdose would present little difficulty to me. I have a bachelor's degree in biology. I did some graduate work in biology. I have a rather decent understanding, I believe, of the nexus between medicine and law, and I don't believe that I would be presented with any additional difficulty as a result of any change in the legislature may have imposed for a drug law. And I would not perceive that as being an additional difficulty, and if anything, it probably affords the Commonwealth an opportunity to impose a more just punishment on those who sell drugs and cause the death of innocent individuals.
Okay, thank you very much, Mr. Hanks.
Thank you, Mr. O'Keefe. I'm well familiar with that statute, and that came about as a result of an appellate case in which it indicated that the Commonwealth needed to prove malice that's equivalent to at least third-degree murder to be able to show that drug delivery resulted in the death of an individual. That is a very difficult burden, especially in a case where you have a decedent and you have to show that a delivery occurred, and obviously your best evidence is that person who's passed away. We can do that through autopsy and through the results of autopsy, but it made it a very difficult prospect, and there were a number of cases that the state police, both in Bell Vernon Barracks as well as Uniontown, have talked with me about before the passage of this statute. What this statute is going to enable us to do is not to deal with the malice issue or the third-degree murder issue. It simply declares it a crime that if, in fact, the drug delivery results in the death, we have to show that the drug was delivered and that, in fact, the decedent died. That's going to ease our burden to do that. There are I believe, I'm not sure there are any cases that have arisen since the statute has passed, because I think it's only been effective for about a month. But we certainly plan on pursuing that. I've talked with the state troopers involved in the prior cases and made them aware that we intend to follow through with that. They are not easy cases, but with
30 seconds.
with drugs in the community as they are. There are dangerous drugs, oxycodone. There's another drug called Opana that we've seen a lot on that has caused some deaths. We certainly are going to vigorously pursue that statute and those kind of cases. And any delivery that results in a death, we are going to prosecute as effectively and fully as we can.
Okay. Move on to the next question. Jerome, we want to take the next question.
Recently, appellate courts have overturned verdicts in 2 homicide cases from decades ago, alleging former prosecutors withheld evidence in those cases. Are there any safeguards that can be instituted to stop this from happening in the future?
Start with Mr. Hanks.
What you have heard through the 2 cases, the Machinsky case and the brake iron case, are things that obviously occurred way before I was the district attorney. Unfortunately, the federal courts have taken an aggressive stance in regard to that. Some of the decisions that you've heard Mr. Cupp recite today, again, I want to emphasize that those are decisions which the Commonwealth won, in contrast to the 2 that you mentioned, the Weimer case and the Siripko case occurring when I was the district attorney. The Siripko case was a 1996 case. The Weimer case was a 1999 case. They had gone through direct appeal, what we call collateral appeal, meaning they alleged their attorneys were ineffective. Mr. Weimer even had a second chance at a trial that we went through, and we went through an exhaustive trial. He then alleged that his attorney was ineffective. We went up through the court system with that. And now, after they've been unsuccessful 1, 2, 3 times, they go back to federal court. We filed those in federal court. That came under Mrs. Vernon, that we filed those in the Weimer case. But nevertheless, we provided, probably took days of our time, of our very scant time that we have, in providing the documents to the federal court. I don't know if they want us to index those things. They were worried that they had to go through and index them. We provided those. We did an index to them. They were provided in what I believe was certainly a sensible way of doing things. So I certainly am proud of our efforts. I'm proud of Mrs. Vernon's efforts in the Siripko case. That was a revolutionary case in Dear DNA. I'm proud of my efforts in convicting Mr. Weimer, because that was a very difficult case that we went through years of litigation, in fact still going through it. And answer to your question is, we try to provide discovery as much as possible. When the police reports come in, we give them to defense counsel. That takes up a lot of our time in making sure the defense counsel has that packet, and I certainly intend to fully disclose to defense counsel all of the information that is exculpatory, that is necessary for them to defend their clients, and certainly I pledge to do that.
Okay, thank you very much. Mr. Cupp?
It is perhaps interesting that you have raised the question about one of the cases that was reversed in the federal system. As luck would have it, I represented Mr. Machinsky for a period of about 11 years. And the critical discovery that was not given was discovered by me in a hearing before Judge Franks. And what had occurred, if I can be demonstrative, is that one of the pieces of paper had been folded like this before it was photocopied, so that a portion of the report was obliterated in the discovery, and that portion of the report referred to things that were never provided and gave rise to the relief that was ultimately granted. There was a trooper who was on the witness stand who had the full copy of the report. And when I was examining him, I was asking him questions from my copy of the report. And he gave me an answer that said that's paragraph 3, not paragraph 4, or something similar to that. And I said, let me see the file that you have.
You have 30 seconds.
Thank you. The file copy that he had, of course, was the whole report. And the copy that the district attorney's office had given me was not the whole report. And I believe in some measure I am the individual who caused that case to come to the front. Different judges make different decisions on different days. The answer specifically to your question, however, is that full discovery avoids appeals and avoids cases being overturned on appeal. And I intend to exercise full discovery in all the cases.
Okay, thank you very much. Okay, Terry, you want to take the next question?
Fayette County prosecutors have not sought the death penalty in a homicide case in several years. What is your view of the death penalty?
Mr. Cupp?
I think the death penalty is a necessary deterrent and a final solution in the appropriate case. And I think that the reason that the death penalty has not been sought is because the prosecutor may not have felt that it was the appropriate case. And I believe that is something that must be determined on a case-by-case basis with a reference to the applicable case law and a concern for the victims as well as their families and the individuals in the community who need to be protected through the deterrence of crime. And I would exercise that discretion, and I would never suggest without knowing a plethora of facts whether I would think the death penalty was an appropriate sanction or not. But I believe that it should be retained as a possible sanction.
Okay, thank you very much.
I think the death penalty exists for the punishment of those type of crimes that fall within the aggravating circumstances that are prescribed by the legislature. I think it provides the ultimate punishment, the ultimate vengeance that a society needs to take on those individuals that have committed the type of crimes that are deemed to be within that aggravating circumstance, and those are usually the crimes that are awful, repugnant to the people in the community. When the prosecutor, and in this case as district attorney, I think you need to take a careful look at the circumstances surrounding those crimes. I think if you look at Mr. Peck's example in Westmoreland County in the kidnapping and the murder, or alleged murder at this point, of the individual, there was several different individuals who were involved in that case. Mr. Peck took a close look at all of those individuals and decided on pursuing the death penalty in some, but not all. I think it's that kind of close scrutiny that you need to do in death penalty cases, because obviously you're dealing with a situation where the ultimate verdict can't be reversed once the death penalty is imposed. I think from a a practical standpoint, that you see the Machinsky case, I don't think it was a death penalty case, but certainly the brake iron case, as the other side of that coin, in the sense that those are the cases that are going to be litigated for a long period of time.
Yeah, 30
I think if the death penalty is truly can be used as a deterrent, that you need to have a speedier disposition of those cases. There have been a couple of people that are, Mr. Blystone, still awaiting the death penalty that was imposed back in the 80s. So I think it has to be done on a systematic way, imposed so that society knows it is protected and the defendants know that they're going to be prosecuted for the ultimate penalty.
Okay, thank you very much. Okay, I'll take the next question. What's your viewpoint of plea bargains? Some say they are necessary to keep the courts from getting bogged down, while others say to give defendants breaks they don't deserve. Do you think we have too few plea bargains or too many? I'll start with Mr. Hennigs.
Well, the system could not operate without a plea bargain process. As I indicated, I'm proud of our office, our organization of our office, how we try cases. We, as I indicated, I think at the outset, we tried about 200 cases in the last 2 years, and in fact, there's still a couple months left in this year. That's an enormous amount of cases, and we have 1 week a month that is trial court week. Certainly, we have been exploring some alternatives to that, but I don't have the authority. I think Mr. Cupp, the last time we were here, suggested that kind of like on a wave of a wand, that we could change the 1 week a month criminal justice system in Fayette County. But the judges are responsible for that. We act within that, and we certainly try to get as many cases through the system as we can. But if you look at each criminal court week, we have approximately 80 to 100 cases that are on the criminal court list. Obviously, we can't try 80 cases a week. So the plea bargain process is necessary. We have guidelines that are in place that we abide by, that our office abides by, the court abides by. We have a probation office that does the appropriate record checks and makes sure that we're doing the appropriate sentences. So it's something that is frankly a necessary evil, but we would not be able to operate without a large expenditure of money, more district attorneys, more public defenders, more judges in the system if we were to try all those cases. So I think plea bargain is an effective way of doing that. What we're trying to do is do it at the early stages, at the preliminary hearing, where our ADAs go out. That's a time where the defense counsel, defendant, ADA, police officer, witnesses, victims are all there. We try to see at that point what that case is like, what we should do with that case, and I've been trying my best to be able to make sure that that plea bargain that was done at the preliminary hearing with all parties consenting is something that can be used as a basis for ultimately resolving that case. And what we try to do is certainly be fair and be consistent, but it's certainly something that the criminal system could not do without. And our best way of doing that is to make sure that we do justice for the victim and make sure the victim is protected, but also result in an efficient way of administering the system.
Okay, thank you very much. Mr. Cupp?
A plea bargain is basically an agreement on whether or not the individual who is charged is guilty of commission of the crime or has no defense to that crime, which is a nolo contendere plea. The most you can expect from a jury is a guilty verdict. If someone enters a plea of guilty, then that plea is the same as a conviction by a jury. The intonation of a plea bargain is that some lesser punishment is exacted from the individual in order for that individual to consent to agreeing that he committed the crime. To the extent that the statewide guidelines are applied and someone is willing to acknowledge they committed a crime and accept the punishment that they would receive in the normal course of events, then it only makes sense for the Commonwealth to accept that plea and allow the judge to impose the sentence.
You have 30 seconds.
In the circumstances in which individuals seek an acquittal, it becomes necessary for them to go to trial. So the plea bargain system is basically a system wherein both the prosecution and the defense agree that the person has committed the crime and agree that the standard range of sentences should be imposed. And I think that that accounts for a great deal of judicial economy and makes the system work. And I don't think we could be without it.
Okay, thank you very much. Okay, this will be the final question there. Jerome?
What do you think the biggest problem facing the district attorney's office is, and how would you plan to deal with it?
We'll start with Mr. Cupp.
I think the biggest problem that faces the district attorney's office is a complete lack of organization, as shown in those 2 federal court decisions. The fact that I go to court and I sit there and the judge sits on the bench and we wait to see the district attorney show up and he doesn't come till 5 minutes late. I think that the problem is that there is no order to the district attorney's office, and that is something that I would change.
Okay, thank you very much. Mr. Hendricks?
If we weren't organized, we wouldn't be able to try 200 cases a year. And I take great offense at the blatant, bold accusation that we are not organized. We process 3,000 cases a year. We have plea bargains, guilty pleas that this last week we had approximately 50 guilty pleas during 40 to 50 guilty pleas during court week or just before that. That is a standard that I'm proud of. I'm proud of our record, our conviction record. I believe that I was at a seminar with Mr. O'Keefe, and Judge Leskinen indicated I think the nationwide average on convictions is 67%, and we're above that percentage. So I'm proud of the way my assistant district attorneys proceed with the cases. Mr. Cupp makes a big deal of the fact that he's tried 2-3 cases and had a mistrial in one that resulted in a guilty plea later on. He fails to mention he just tried a case a couple months ago and that his client was convicted by Michelle Kelly from our office. I don't want to make this a mano kind of thing, but if Mr. Cupp wants to indicate a 10 or 11-year-old case is somehow reflected of his abilities to manage that office, then I disagree. In addition to that, he cites the 2 cases in which we, in fact, received a decision that upheld the convictions, and I'm proud of the fact that both Mr. Siripko and Mr. Weimer are in jail because of both Mrs. Vernon's efforts and my efforts to do that. But he also fails to tell you about, in fact said he represented Mr. Machinsky. There's a 1990 decision by the Superior Court.
You have 30 seconds.
And it indicates, and I won't go through it, it's too long to do, but basically says appellant's counsel, who is Mr. Cupp, in flagrant violation of the rules of appellate procedure in briefing this case, has inundated this court with an appellate brief of 233 pages, including appendices. The statement of issues involved is so convoluted and serpentine in expression and logic as to provide extreme difficulty for this court to extrapolate the essence of the arguments from irrelevant and inappropriate argument. And in fact, he said, that they would go on to decide the case, because otherwise it would be great expense to the court, and it would return to the court because of ineffective assistance. Having been notified of his dereliction, it would not be remiss for this court to direct the disciplinary board of the Supreme Court to review counsel's conduct, particularly if the behavior is repeated. So that's Mr. Cupp's record in arguing the Machinsky case. Obviously, in that case, his client was denied relief. I'm proud of the fact that we do have hundreds of cases, hundreds of appeals, and we've successfully proceeded with those, and very few have been reversed on appeal.
Okay, thank you very much. Okay, well, that concludes our questions from the Herald-Standard.com editorial board. We'll now enter into the closing, where you'll have 3 minutes. You can talk about anything that you want to talk about. We'll start with Mr. Hennicks.
Thank you, Mr. O'Keefe. And again, I want to thank the board, the panel, and the newspaper for allowing us to be here today and discuss these issues. I believe that my service, not only in the district attorney's office, but in fact my service dates back to when I was a public defender back in the 80s, and tried a number of cases as defense counsel, wrote a number of briefs, and in fact several of those briefs resulted in effective outcomes for my clients at that point. But the question that the voters of Fayette County have is whether they're going to elect someone who has been in the courtroom day in, day out for the last 30 years, frankly, and certainly in the district attorney's office for the last 15 years, who has tried the tough cases, tried the child abuse cases, tried the homicide cases, has obtained verdicts in those cases. Even when I was the district attorney, I was able to obtain a third-degree murder conviction in the McMaster case, again, a very difficult homicide case. So I proved that I know my way around the courtroom, know what is effective and what is not. It's difficult for me to believe that someone that's only tried 2 or 3 jury trials in the last 20, 30 years of his practice would know the ins and outs of what it takes to manage a district attorney's office, but also give advice, and what I believe to be sound advice, to my assistant district attorneys. Choose the cases that we need to try, make them able to be successful in their efforts to try those cases. I believe that we have done that I have brought that experience and dedication to that office. I'm very proud of the way our office is organized. We have, as I indicated, these are 2 bits that Mr. Cupp has cited in the vast array of appellate court decisions which we've been extremely successful in pursuing and prosecuting and upholding those convictions. And that goes for the 200 jury trials that we've tried as well. In addition to that, I have brought my experience with the Drug Task Force in bringing Steve Cooper, who was the police chief of Connellsville. He's now the head of our Drug Task Force in the operational sense. We've been very successful, both Mark Brooks, who is my first assistant district attorney, who is our drug prosecutor. There's no one more qualified to do those things in the district attorney's office. So those are the day in and day out work that we do in the district attorney's office, and I am proud of those efforts. In addition to that, we have brought my experience to bear in the mental health field. I was past president of Chestnut Ridge Counseling Services. I have been in that field and in the mental health field as well. Again, I believe that I bring a unique perspective to those issues in regard to that makes me the most qualified candidate to become and to retain and to be your district attorney for the next 4 years.
Okay, thank you very much. Mr. Cupp.
I want to thank you for allowing me this opportunity to speak. I believe that Fayette County needs a strong district attorney who will organize the office to keep cases from falling through the cracks. I will also read the charges prior to filing so that the county won't file improper charges, such as the insurance fraud claims against the Nye-Pavers that were later dismissed by the court as recounted in the August 20, 2011 Herald-Standard article. We also, as Mr. Hennick said, had a case that he had to ask to be reinstated, the Bittner case, where the Commonwealth did not object whenever the defense attorney moved to dismiss the case, and 2 weeks later they decided maybe they should have. It was a Megan's Law registration case, so they had to go back into court and ask the court to allow them to reinstate the charges. I believe the judge said you should read the motions before you agree to them. The motion to dismiss order is also attached to the article. And then there's always the case where the Commonwealth just doesn't bother to bring the cases to trial in time, which is the third page of that exhibit, which is Commonwealth versus Peterson, where the case was thrown out for a Rule 600 violation on March 22nd of this year. I am no one's person. I have no ties to any political clique, and I do nothing with the current district attorney's office. I have no connection to them. The need is for change, and John Cupp will change the district attorney's office. We have grown complacent in our society, and we need a system. We need to change the system to a system that is not inbred and doesn't continue to feed on itself. We need an outsider to bring a breath of fresh air into the district attorney's office. No one can buy me as district attorney. I have spent my own money on my campaign. I have received nothing in contributions.
You have 30 seconds.
I did not solicit money from anyone else, and I will be my own man. I will not be a part of the system that has existed. And I thank you very much for your time.
Mr. O'Keefe, since he brought up two items that we haven't even talked about, I feel that I have...
I'm sorry, but there's...
The only thing I will say is that those cases that he's brought up, one's on appeal. Mr. Bittner and Mr. Nye-Paver are still facing trial, and certainly we brought those charges based on the law. The judge sometimes rules against some of those charges, but they are both ongoing prosecutions.
Okay, well, I want to thank both candidates, both Mr. Hennick and Mr. Cupp, for agreeing to meet with us here at the Herald-Standard.com editorial board. And I want to thank you out there for watching. We'll see you later.